matter decree on the application and for Islam.
Yes, good morning, Mr. Malik.
Good morning, Milady, my lords. I appear for the appellant this morning. My learned friend Lord Murray appears for the Secretary of State.
Yes, good morning. Yes.
Milady, my lords, there is a significant shortage of care workers in the UK. The role of a care worker therefore appears on the skilled occupations list in the immigration rules. The appellant seeks to work as a care worker. He has been offered a job at a healthcare provider and was issued with a certificate of sponsorship. With that certificate of sponsorship, he made an application for leave to remain to the Secretary of State as a skilled worker. The Secretary of State declined to consider that application, rejecting it as invalid. The Upper Tribunal has refused permission to apply for judicial review in respect of that rejection, and this is an appeal from that refusal. I shall seek to persuade my lady and my lords that the Upper Tribunal erred in holding that the appellant's claim was not arguable. Contrary to the Upper Tribunal's conclusion, the Secretary of State erred in her approach to the immigration rules in rejecting the appellant's application as invalid.
So the proposition for the UT was that the Secretary of State had, you say, erred in her approach?
Yes, to the discretion under the immigration rules.
Erred in her approach to the discretion under the immigration rules?
Yes.
Yes.
So subject to any observations, what I propose to do this morning is to address you first on the law, and will then make some very brief submissions on the facts and the decisions made below. So start with the law first. My lords, the ultimate authority as to how one should read the immigration rules is the judgment of the Supreme Court in Mahad. You have that authority behind tab 7 of the authorities bundle. Starts at page 205 of the PDF bundle. Now, the issue before the Supreme Court in that case was about the construction of the maintenance provisions in the immigration rules. If you look at page 209 of the bundle, you will see that the relevant immigration rules are set out at the outset. And you'll see that those provisions included a provision that the parties will be able to maintain themselves and any dependents adequately without recourse to public funds. Now, this court had held that on a proper construction of that rule, third-party support was not permissible. So it wasn't open to an applicant to rely on the funds of a friend or a family member in order to qualify. An applicant may only qualify if the parties, the applicants, are able to maintain themselves from their own funds. If you look at paragraph 10 of the judgment, this is the judgment of Lord Brown, page 211. You'll see that Lord Brown there referred to MO Nigeria. And you'll see from the quotation that the question as to the construction of the immigration rules depends on the language of the rule construed against the relevant background. And if you look at the next page, page 212, And if you look at the text that appears between B and C, you'll see that Lord Brown observed that the rules are not to be construed with all the strictness that is applicable to construction of a statute or a statutory instrument, but instead sensibly according to natural and ordinary meaning of the words used. So the focus must be on the words used in a particular rule, and there must be recognition that the rules are statements of the Secretary of State's administrative policy. Now, later in the judgment, Lord Brown identified what in my respectful submission is a helpful tool to ascertain the proper meaning of a rule. And that is a tool that I would respectfully invite Milady and Milords to deploy in the present case. Now, may I take you
Could you just repeat what you just said? Because I was moving on. You said later in the judgment.
But later in the
it was said-
judgment, Lord Brown identified what in my respectful submission is a helpful tool to understand, to ascertain the proper meaning of the immigration rules. And that is the tool that I would respectfully invite Milady and Milords to deploy in the present case. Now, if you go to paragraph 26 of the judgment, page 216, so I have already shown you the rule that was in issue before the Supreme Court. Now, at paragraph 26, Lord Brown referred to certain other provisions in the immigration rules, the rules that expressly excluded third-party support. For example, if you look at the quotation that appears just above paragraph 27, you'll see that the phrase "from his own resources with no assistance from any other person" appears. So what Lord Brown then did was that he sought to compare and contrast the language of the rule that he was dealing with and the language of the rules that were found elsewhere. And then he sought to ascertain the proper meaning.
So you can use contrasting provisions as a guide.
Yes. So paragraph 27, the appellants argued that if the Secretary of State had intended to prohibit third-party support in relation to the rules in issue, then this is the sort of language that the Secretary of State would have used. And that point, you'll see, received some approval at paragraph 28, right at the end of paragraph 28. If the Secretary of State was intent on ruling out third-party support in family reunification cases, then he could have perfectly well have made that plain by using the same sort of language as in the other parts of the immigration rules. Now, can I, with that approach in mind, can I take you to the relevant immigration rules? The relevant immigration rules appear behind tab 1 of the bundle. This is page 2 of PDF. So this is the entire appendix skilled worker. And if you look at page 7, you will see validity requirements for a skilled worker. And you'll see a number of requirements. A skilled worker, for example, under paragraph SW 1.1, must apply online. The applicant must pay fee and immigration health surcharge, it's 1.2. The applicant must be over the age of 18, it's 1.3, and so on. The provision that is in issue is paragraph SW 1.5a, which is at page 8. And you'll see that it says that the applicant who is applying for permission to stay and has or last had permission as a student must fulfill one of the conditions A, B, and C below on the date of the application. Now, the consequences of failing to meet a validity requirement is identified at paragraph SW 1.6, which appears right at the end of page 8. An application which does not meet all the validity requirements for a skilled worker may be rejected as invalid and not considered. The use of word may in my respectful submission speaks for itself. There is no mandatory or automatic rejection if any of the requirements are not met. The Secretary of State has a discretion. The Secretary of State may accept an application as valid and consider it even if one of the requirements in paragraph SW 1.1 is not met.
How do you square that with the word must in every single paragraph that goes up to SW 1.6?
So the requirements that are set out at SW 1.1 to SW 1.5a, Milady is absolutely right. The use of must appears.
Mandatory, aren't they?
Well, yes, the applicant must meet those requirements.
If he doesn't meet those requirements, then he's not fulfilling the specific criteria that the Secretary of State requires in order for his application to be a valid application.
I have, Milady, with respect, I have no difficulty with that approach. My submission is that once the Secretary of State has reached that stage and has formed a view that one or more of the validity requirements are not met, the Secretary of State has a discretion.
Yes.
The discretion is under the immigration rules, and the word may is not will. The Secretary of State could have said, well, an application which does not meet the validity requirements will be rejected as invalid and not considered. And what, in my respectful submission, Milady and my lords are asked to do by the Secretary of State is to read word may as will.
But is that right? Is that right? If the Secretary of State were to consider exercising a discretion, she would be considering the application, wouldn't she?
Well, the Secretary of State, in my submission, will be considering whether to consider the application on merits. So the way in which the requirements are set out, these are validity requirements.
So I fully understand your submission, which is that there is an obligation to consider whether to consider.
Yes.
That's what it comes to, isn't it?
Yes.
Right.
So once the Secretary of State has reached that stage, and the Secretary of State took the view, just to answer my lord's question, once the Secretary of State reached a point where she concludes that one of the validity requirements are not met, she then, in my respective submission, must exercise a discretion under SW 1.6 in order to decide whether to consider the application on merits or whether to reject it as invalid.
And in practical terms, now, I mean, no doubt a number of invalid applications are filed in the scheme of this kind. So that obligation arises in respect of every application, valid or invalid.
In my respective submission, yes.
Yes.
Yes. And I will seek to make that submission good by reference to an authority that I'll take you to.
Yeah, but we have no authority directly on this point. I think otherwise you'd have shown it to us.
Yeah, of course.
But I also just check this with you. I find that this precise formula appears elsewhere in the skilled workers.
Yes.
So I think it's one of 4 appearances, and in a sense, your submission covers all of them. They're for different types of visa, within skilled worker, but it's exactly the same point wherever it appears.
I mean, so far as the validity requirements are
Yes.
concerned, yes.
Yes, I mean, it's a formula which is dropped in at various points at the end of the validity requirement for each of the visa types.
Yes. Now, this sort of rule is not unique to appendix skilled worker as such. There are similar provisions in relation to a number of different categories, and this court and the Upper Tribunal has grappled with the effect of these sort of provisions in a number of cases. And in my respective submission, I have made it clear consistently that these are discretionary provisions.
Are these decisions that you're going to take us to, because we need to
Yes.
to see them to understand how you put it, are these provisions in relation to validity requirements?
No.
But I mean, I think we need to keep, because I mean, here we have validity, we have eligibility, and we have suitability, don't
Yes.
we?
Yes.
And as I understand it, and you'll be better able than I, the whole point of this is to eliminate discretion to the greatest possible extent. That it is a points-based formulaic system that is designed to reward those who meet the system and to say sorry to those who don't.
Yes, my lord, I will show you the rules that the Secretary of State has formulated to eliminate discretion altogether. And that is the reason I took you to the relevant paragraphs at
Yes.
Mahad.
And just to, again, checking, SW1, 5A and 1.6 both came in at the same time, didn't they? 6 was there before?
6 was there before,
Oh,
yes.
so 5A was dropped in.
Yes. Yes.
Thank you.
Yes.
Yeah, on your analysis, the wording could be maybe reject as invalid. What do you say the words "and not considered" add?
Well, that in my submission means that where the Secretary of State exercises the discretion to reject an application as invalid, then the Secretary of State will not consider it.
But that must go. That seems to be tautologous, isn't it? If it's invalid, then it's not considered.
The word would be superfluous.
Unless it has more meaning, which is that you don't even exercise a discretion, consider a discretion. That's the only thing it can add, isn't it?
Well, may be rejected in my submission means that there is a discretion at least, and the phrase "not considered" in my respective submission must be read in that context. If you read the words "not considered" in that way, then my respective submission is that would make the use of "may" redundant.
Well, the word "may," you say it imports a discretion, but what it actually does in the first instance is bestow a power. If you may do something, it's giving you a power to do something. And what it's giving you a power to do is to reject it and not consider it. It means that you can do something different, but you have got that power to reject and not consider.
Well, I, my lord, have no difficulty even with that approach. So whether you name it as a power or discretion, in my submission, it makes no difference to my argument.
Because you say you've got to consider whether to exercise the power.
Yes, there is a power or discretion, but not an obligation to refuse the application. And there are provisions in the rules where there is an obligation.
I'm sorry to speak over you, but you say there's an obligation to consider whether to consider.
There is, yes.
I mean, that's where your obligation comes in.
Yeah, the way I put it with respect is that there is no obligation to reject an application as invalid where the validity requirements are not met. There is a discretion that the Secretary of State must appreciate and exercise one way or another.
But if you have a power to reject and you exercise the power to reject, which the Secretary of State has done here, then what's the complaint?
Now, this is not, and I hope to demonstrate this in the course of my submissions, this is not what the Secretary of State has done. If the Secretary of State appreciates discretion and exercises it by refusing the application, by rejecting the application, then that rejection may only be challenged on Wednesbury grounds. But where there is a failure to appreciate the discretion, then that is a public law error. So failure to appreciate and exercise the discretion is a separate public law head under which a judicial
And to
review can
escape
proceed.
that, then the letter that's sent out has got to say, I notice that your application is invalid. I've considered whether I should nevertheless consider it as if it was a valid application. I've decided that I should not do so.
If the Secretary of State says that, then that rejection may only be challenged on Wednesbury grounds. If the Secretary of State had done that, I would have been making an
Then you'd be
argument.
arguing about reasons, wouldn't you? You'd say, well, if my Lord's formula was put in, you'd say, oh, well, there's an exercise of discretion and she hasn't given any reasons for going down this road rather than the other road, so we're going to challenge it on Wednesbury grounds.
Well, yes, but in that,
Well, I think the reasons would be the reasons why I've decided not to consider it is because it's an invalid
Valid.
application. So it at the moment it seems to me to be an entirely empty
Yes.
statement.
yes, I'm just giving an example. There is a provision that says that an application must be made online. Now, what if a person makes a paper application and explains in a cover letter as to why it is not possible for that person to apply online? What if there was a breakdown in the online portal? The visa is just about to expire. The person makes an
So
application.
that gives the Secretary of State some latitude,
Yes.
which she choose to exercise for cause.
Yes, but that would be an exercise that the Secretary of State, in my submission, would perform not outside the immigration rules, but under the immigration rules, under paragraph SW 1.6. So there is, in other words, if that requirement is not met, there is, as I said respectfully, there is a discretion, but not a duty to reject the application. Now, can I just show you another provision in the rules that may assist? If you look at the next page, page 9, you'll see suitability requirements. You'll see eligibility requirements, and given that Milady asked a question as to the use of word must, you'll see that the word must appears in all these provisions
As it does in
in the validity
SW
requirements.
1.1, 1.2
Yes.
and 1.3.
Precisely, yes. So suitability requirements, you must not fall for refusal under general grounds. You must not be in breach of the immigration rules. And then you have a series of eligibility requirements. Well, you must apply entry clearance. You must obtain a medical
So what's the
certificate.
answer there? No discretion.
Well, yes,
I mean, that points to the absence of discretion, for example, in relation to suitability requirements.
yes. So far as the validity requirements are concerned under 1.1 to 1.5a, they are not very different from these requirements. The word must is used throughout.
But can you help as to why the position of an applicant should be better in relation to the validity requirements than they are in respect of the suitability
Of
requirements?
course, yes. So you have seen suitability requirements, you have seen eligibility requirements. Can I then just show you a paragraph that deals with the consequences of failing to meet the suitability requirements and the consequences of failing to meet the eligibility requirements? And that paragraph is at page 31. You'll see a heading, decision on an application as a skilled worker.
Hold on a second, Baptist. Page 31.
Yes. Now, and see the language that is used in that paragraph. If the decision maker is satisfied that all suitability and eligibility requirements are met, the applicant will be granted. Otherwise, the application will be refused.
Could you please just give me the reference again, because I thought I
My
found
apologies,
it.
yes. So page 31 of the bundle,
Yes.
paragraph SW 17.1. You'll see a heading, decision on an application as a skilled worker.
Right.
if the suitability and eligibility requirements are not met, the rule says the application
Right.
will be refused.
This was the point of my question, which is that you're drawing attention to the musts and the wills
Yes.
which relate to suitability and eligibility. My question
Yes.
for you was, why should it be better for the applicant under validity?
Yes, of course. So
Because there isn't any narrow gap for the Secretary of State
Yeah.
there. Why should it be? Why should a discretion arise
Yes,
in
of
relation
course.
to validity, which doesn't arise in relation to the other substantive matters?
entirely fair and question, my lord. If you look at 17.1, and you'll see how the rule ends, the application will be refused.
Yes.
So where the relevant suitability and eligibility requirements are not met, the application will be refused. There
Yes.
is no discretion.
Yeah.
The refusal is mandatory. The Secretary of State has no power to grant leave to remain where the suitability and eligibility requirements are not met.
You still have the power to do it outside the rules.
Yes, outside the rules. So if the Secretary of State, there are exceptional circumstances, the Secretary of State may exercise a residual discretion, grant leave to remain outside the rules, but that will not be leave to remain as a skilled worker. That would be a discretionary leave to remain, a leave outside the rules. But where the requirements are not met, the application will be refused. Now, if you then just keep that in mind and go
Yes.
back to page 8,
Mhm.
and then compare the language with the language that appears at 1.6. So why is it, I respectfully invite Milady and Lords to consider that the Secretary of State has used the word may in SW 1.6 instead of will, as she had used at 1.7. If the, and this is the point that this is the point that Lord Brown was seeking to make in Mahad, that if the Secretary of State intended to have mandatory requirements, if the Secretary of State intended to have a consequence that an application will be rejected as invalid if the validity requirements are not met, this is the sort of language that she would have
Yes.
used, the language that you have at SW 1.7.
But I quite see the point that you're making there, which is the contrast point and the language choice point. But I still fail to understand why the Secretary of State, Parliament, would seek to bestow a discretion on a decision maker in relation to an invalid application that it hasn't seen fit to bestow in relation to a valid application. That seems to be completely counterintuitive.
Two points that I'll make with respect. The first point with respect is that one must, as the Supreme Court has told us in Mahad, must focus on the language used in the rules. And again, this is the point that Lord Brown made at paragraph 10, that the intention of the rules is to be ascertained by reference to the language that the Secretary of State has used, as opposed to other
So
considerations.
if it is completely intuitive, then so be it, is your answer. It's what it says.
Yes.
That's really what it comes to.
So far as my first point is concerned, there are many provisions in the rules that, in my respective submission, are difficult to follow, or it's rather difficult to understand their objective. But what the courts have sort of consistently said is that you focus on the language of the rules.
Yes, but are you accepting the
The-
point that you just made against yourself, as it were, that it would be difficult to understand why Parliament should have done this?
So that my lord, is the second point. I'll come to that in a minute. But my
Okay.
first submission is that you must focus, in my respective submission, on the language of the rules and focus on the use of word may and the use of word will in the two paragraphs. Now, the second point is that in any event, there may well be good reasons as to why the Secretary of State has used the word may so far as the validity requirements are concerned, but will so far as the suitability and eligibility requirements are concerned. So if, for example, just looking at the suitability requirements, if a person is in the UK in breach of the immigration law, then that evidently is a matter that the Secretary of State would deem as serious, and a matter that would lead to an automatic mandatory refusal of the application. Likewise, if a person is not a skilled worker, he does not meet the eligibility requirements, he does not have a certificate of sponsorship, then that again would be a requirement, a matter that is serious enough so as to justify an automatic refusal. But those sort of considerations, in my respective submission, do not apply, or do not apply with full force when it comes to the validity requirements of the rules. A person has not been able to make an online application through the website. If that person has a good reason for not being able to make online application, if that person meets the suitability requirements, the eligibility requirements, it may well be that the Secretary of State would want to look at that application on merits and decide whether to consider the application and then whether to grant it, despite the fact that there is a procedural problem with the application. So the difference between the validity requirements and the other requirements is procedural versus substantive.
Well, what if the sponsor misspells the applicant's name in the certificate?
Well, that I think would be one of the eligibility requirements. I'm not sure, Lord, if you
I
have
see.
a particular provision in mind.
So eligibility is
Yes. So
a discretion, is it?
no, the eligibility is mandatory. So if the eligibility requirements are not met, the application will be refused. Just to answer the point, if you look at page 14 of the bundle, you'll see a heading points for sponsorship.
Yeah.
And there is a rule that concerns SW 5.1 says that the applicant must have a valid certificate of sponsorship,
Confirms their name.
which to be valid must confirm the applicant's name.
Mhm.
Now, if there is no valid certificate of sponsorship, then the eligibility requirement is not met. The consequence under SW 1.7 is that there is no discretion. The Secretary of State must refuse the application.
That's what I'm asking you. Does that mean if the sponsor misspells the applicant's name, then it must be refused? I mean, because I think what you're saying is that what we're asking you is why does validity give rise to discretion but eligibility doesn't? Just trying to understand it.
Well, because the validity is a procedural requirement, eligibility, suitability are substantive requirements. So that is the difference, and that in my submission explains why the Secretary of State has decided that there should be discretion in SW 1.6, but no discretion in SW 17.
I'm sorry, Mr. Malik, that won't wash. SW 1.5A is a substantive requirement, not a procedural requirement. They've got to fulfil. They've got to be actually studying at an appropriate course, haven't they?
Yeah.
And they've got to and they've got to have a certificate of sponsorship. They must have a certificate of sponsorship in the other.
Yes. Yeah, I take it.
Substantive requirement. I
Yes,
think.
lady, if the Secretary of State wanted SW 1.5A to be a substantive or eligibility requirement, then instead of having 1.5A here under the validity requirements, she could have added a provision, a similar provision in the eligibility requirements.
Well, she could, but it's been put in the validity requirements to narrow the gateway through which people can apply when they're students for skilled worker status, to stop the flow that was coming through. That's the historic reason for it, isn't it? But it is still, although it's a validity requirement, it's not purely procedural. That was the only point I was putting to you.
Milady says that the intention was to narrow the gap. I don't have a difficulty with that, but the intention was not to exclude such applications completely. Completely accept that the intention was to narrow the gap. But there is still a discretion. No matter how one looks at 1.5a, this is still a validity requirement.
Well, isn't the distinction that in 17.1 is based upon the fact that this decision maker has obviously considered the application and checked through to check that the suitability and eligibility requirements are met. So that is a full consideration, detailed consideration of the application.
Yes.
And if those elements aren't met, then it will be refused.
Yes.
So what you have in validity is a preliminary look which entitles the Secretary of State not even to consider it if it hasn't met the validity requirement. So it's an initial threshold to pass, which means they don't even have to think about this application.
Well, I'm with respect, I'm absolutely fine with that approach. If there's a distinction between preliminary requirements and substantive requirements, I'm fine with that.
But how could the Secretary of State properly exercise a discretion as to whether or not to permit the application to be treated as valid without actually taking into account relevant considerations, which is what's in the application? If there was a discretion,
Yes.
she'd have to consider the application, wouldn't she? She couldn't ignore everything that was said in the application when exercising a discretion.
When exercising a discretion as to whether to consider the application.
Yeah, but I have difficulty with the concept of exercising a discretion as to whether to consider, which means which is done without looking at the application.
Yes. Can I perhaps just give my lord an example that may assist? So if you look at page 8, if you look at SW 1.5ZA, you'll see that there is a procedural or preliminary requirement. I don't have a problem as to how one puts it, that you must not be in the UK as a visitor. So if you come here as a visitor, you're not able to make an application. You must leave the country, apply for entry clearance from abroad, and your application will be considered by reference to suitability or eligibility requirements. Now take the example of a person who comes from on a visitor's visa from Syria or a country say Ukraine. There is war. That person says that, well, I'm here as a visitor. There is now a war in my country. It's not possible for me to leave the country, to apply for entry clearance, and to come back. So although I'm here as a visitor, although the rule says that, well, you must not be in the UK as a visitor, there is a discretion. The circumstances are such that you should exercise that discretion and look at my application. My proposed reading of SW 1.6 will enable the Secretary of State to consider that sort of.
It sounds much closer to an application outside the rules.
Yes. So, but that
I can't imagine why one would one run one's head against the provisions of SW.
Yeah. No.
In that situation.
Yeah. So the reason being that the reason being that there is a discretion within the rules, as opposed to.
Yes, I understand that one. Matter of interest. I mean, I was looking at the letter, and you get your fee back when your application is rejected, but they charge you £25 for the administration.
I think that's right. Yes.
Yes. I don't suppose anybody knows what the fee is.
Yes, it's on the, it's 956, but it's on the application
956.
figure, the precise figure, just on the top of my head. It's in the bundle. Yes, page 79, 979.
Sorry, 970.
9. It's at page 79 of the appeal bundle.
Thank you very much. Sorry, Ms. Mate, that was a tangent.
No, not at all. So the question that is put to me is that, well, in that sort of situation, that could be an application outside the rules completely. Now, Millennium cites an authority. You look at it in due course, obviously, where the mandatory requirements of the rules are not met, where a student is required to meet eligibility requirements. The eligibility requirements were not met. The rule says that refusal is mandatory. Now, this court has said that, well, in those circumstances, if a person in the application invites the Secretary of State to exercise discretion outside the rules, the Secretary of State must look at the facts and decide whether to depart from the immigration rules. But where there is a discretion under the immigration rules, in my submission, a far better course to adopt is to consider the application under the rules.
Right. Well, now you were going to take us to some cases where you took.
Yes. So I've shown you the relevant rules. Can I then just show you the authorities as to the proper approach to the discretion?
Which ones are you going to take us to?
Well, three authorities in turn. The first one is UCAS.
Thank you.
UCAS is behind tab 9 of the authorities bundle. You see that this is a decision by the Upper Tribunal's Deputy Vice Presidential Panel. It reflects well settled position in this jurisdiction. If you look at the judicial head note, paragraph 2, where the decision maker, and I'll show you what the rules were there, where the decision maker has failed to exercise the discretion vested in him, the tribunal's jurisdiction on appeal is limited to a decision that the failure renders the decision not in accordance with the law. So that's a separate public law error. And what the court must do is require the Secretary of State to complete the task by reaching a lawful decision.
Yes.
And you'll see a reference to Abadi. Now, if you look at paragraph 2 of the judgment, page 235, you'll see the relevant rules. Now, the rule said that an application should normally be refused. There are provisions that say that an application must be refused. It says normally be refused. So there is a presumption of refusal where a person falls within the ambit of that rule. And if you look at paragraph 3, you'll see that the expression normally be refused reflects a discretion to be exercised by the decision maker. Even in a case where there is presumption, there is a discretion. But here, the rule that we are dealing with, there is not even a presumption. It does not say that an application should normally be rejected as invalid. It simply says, well, may be rejected as invalid. Now, what was happening at that time was that the Secretary of State or the Entry Clearance Officer was producing decisions refusing applications without paying any regard to the discretion that was built in. And this reported decision deals with that problem. Now, if you look at page 237, you look at paragraph 11, you'll see that the Upper Tribunal identified how one can consider whether the impugned decision has been lawfully made. And if you look at Roman 2, you'll apply the judicial review. The tribunal says you apply judicial review standards. And Roman 2 says, by considering whether the decision maker has appreciated the past, whether you call it a power or discussion, vested in him by reaching a decision that properly recognizes them.
Well, this was a case about whether, putting it in the baldest terms, there were compassionate circumstances.
Uh,
Isn't that what this was all about?
No. So, so Part 9 of the immigration rule says that, well, your application should normally be refused if you fall under these provisions. And then there is a list of many provisions. For example, it says if you have used deception in a previous application, your application should normally be refused. If you have a conviction, your application should normally be refused. So there is a discretion. And that was the point that the Upper Tribunal was dealing with. So you've seen paragraph 11. If I ask you respectfully to look at paragraph 12 as well.
Sorry, I'm just. Yes, paragraph 12. Thank you.
Yes, Lord. Given if the point is troubling you, this wasn't about compassionate reasons as such. So if you look at the rule that was an issue, this is paragraph 2.
Yes.
So the Secretary of State has to decide whether admission would be justified for strong compassionate reasons. If the Secretary of State concludes that there are no strong compassionate reasons, there is no automatic refusal. There is a discretion that must be appreciated and exercised. And paragraph 12 then says.
I was just looking at paragraph 5,
Yes.
which is the decision which was made in that case,
Yes.
where it was something to do with separation, wasn't it? The consideration was given to the compassionate circumstances, but they weren't compelling enough for the application to be granted.
Yeah.
So, I mean, I obviously may have mangled it in reciting it back to you, but
Yes.
in that case, what was happening was an assessment of the compellingness of the compassionate circumstance, which is a classic evaluative decision for a decision maker in this situation. And that was really my attempt to understand what this analysis of 11 and 12, which you're taking us to, was biting upon.
Okay. Now, my submission is that that is a case, and Lord, the next example perhaps is a better example that deals directly with this particular point. But that is a case where, in my submission, the Secretary of State had decided, the intelligence officer had decided that there were no strong compassionate reasons.
Yes.
And the Secretary of State had then, the intelligence officer had then said that, well, I have considered exercising discretion. To put it as plainly as possible, there is a presumption for refusal. There isn't anything compelling, and I exercise my power to refuse the application.
I'm not sure that's right, Mr. Malik. If you look at paragraph 12,
Yes, so
the discretion was whether or not what he knew that he was applying the rules. He acknowledged that involved him in the exercise of discretion, which was discretion to determine whether there were exceptional compelling circumstances, compassionate circumstances. Then identified the factors to take into account, which included compassionate circumstances, balance them against each other, and reached the conclusion that they weren't of a sufficiently compelling nature with the exercise of the discretion. I mean, it's not saying, oh, there are no compelling circumstances, and yet there's other factors that I need to do.
Lady, this is not how, with respect, I will invite you to read this paragraph. When I'll take you to the next authority, you'll see that deals directly with that point. So there is a two-stage analysis. The first stage requires the decision maker to consider whether there are compassionate circumstances. If there are none, then there is a discretion, a second stage discretion. Well, an application can be granted, can be
because
refused.
the normally will be refused.
Yes, so that would be. But how you assess whether the Secretary of State has made a lawful decision, in my submission, is by reference to the formula that appears at paragraph 12. See if the Secretary of State has recognized the part of the immigration rules that they were applying. See if there is an acknowledgement that there is a discretion. Identify whether the decision maker has identified the relevant factors, conducted a balancing exercise, and then decided to exercise discretion. And the Upper Tribunal said that, well, in that case, the anti-criminalist officer has made a lawful decision. That was a classic exercise of lawful discretion, but that isn't this case. So that is UCAS. The next authority is Balaji Gari. This, as Milady and Milords may have seen, is a tax discrepancy case. Milady certainly has dealt with these cases.
You had one only last week, Mr. Mullen.
Okay. So the issue before the court was about paragraph 3225 of the immigration rules. And if you go to page 126, you'll see a heading, paragraph 322. And if you look at paragraph 25, you'll see that rule had two parts. The first part said that an application that leave to remain and variation of leave are to be refused. In other words, mandatory ground for refusal. Now, this concerns where a person has been convicted of a criminal offense, where various criteria as to the length of sentence is met. So, where there is a sentence of more than 4 years, for example, an application must be refused or to be refused. But then look at paragraph 26, where the court compared it with the part that concerned an application should normally be refused. That was paragraph 3225. And the relevant rule is set out at 27. So an application should normally be refused where, for example, there are where a person has made false representations in a previous application, or just looking at page 127, paragraph 30, where the Secretary of State deems exclusion to be conducive to public good because of a person's conduct, character, and associations. So undesirability of permitting the person to stay in the UK. And this court considered the difference between the mandatory and discretionary
I
refusals.
see that, but it seems to me that you're setting up a very large target to aim at, because these are all matters which are concerned with classic evaluative decisions of the substance of an application, where it could not sensibly be said that discretion did not have to be exercised. In fact, the whole point of the decisions in those cases were that they were discretionary decisions. I mean, I think you're in danger of assuming the proposition that you are here to prove, and these cases seem to me to have nothing really to tell us about what happens when you simply file an invalid application.
Yeah. So yes,
But I don't wish to stop you, but yeah. I mean, they seem to me to be in a different part of the room.
Yes, Lord, can I just seek your indulgence just to show you a couple of paragraphs that may settle the concern. Yeah. Yes. So if you look at paragraph 1, page 127, you'll see a heading, the correct approach.
Yes.
Now, and this may assist Milord in relation to the questions that Milord is asking. The discretionary provisions involve a two-stage analysis. So this was the question that was being put to me when I was showing you UCAS. The first stage is to decide whether the rule applies at all. That is, whether it is undesirable to grant leave in the light of specified matters. And the second stage, if the rule applies, so the first stage is an evaluative assessment whether it is undesirable for a person to stay in the UK. But once the Secretary of State concludes that there is undesirability, there is a second stage, and undesirability is a presumptive rather than mandatory ground to decide as a matter of discretion whether leave should be refused on the basis of it. So here, in this context, the Secretary of State in my submission must apply the two-stage analysis. The first stage would require the Secretary of State to consider simply whether the validity requirements are met or not. If the validity requirements are not met, then that is the first stage of the analysis. There is no evaluation.
So the submission is that the Balajigari paragraph 33 template is apt for the case in point that we have.
Yes, but of course, subject to this modification that so far as the validity requirement is concerned, there is no evaluative exercise so far as the first stage is concerned. You simply look at whether the validity requirements are met or not. If those requirements are not met, then you look at the second stage. And what is said about the second stage is that as a matter of discretion, whether leave should be refused on the basis of it.
Right, understood.
And the submission is that the second stage in this context would require whether discretion should be exercised to reject an application on the basis of it.
Understood that, yes.
Good.
Okay.
So that is how I put my submission. Now, there is then guidance at 128 as to the first stage undesirability. That does not apply. But if you look at the second stage discretion, this is 129, you'll see that the submission was made that, well, even where a person falls under the rule, the Secretary of State must separately consider whether, notwithstanding the conclusion that it is undesirable for the applicant to have leave to remain, in this context, where notwithstanding the fact that the validity requirements are not met, how the discretion should be exercised. And the Secretary of State at that point should look at all the circumstances and decide how to exercise that discretion. That's how I put my case.
Thank you very much.
One final authority where UCAS and Balajigari approach was considered, and that is the judgment of this court in Yassin. This is tab 10 of the authorities bundle. The court dealt with a similar provision. The decision maker had treated the discretionary rule as if it was a mandatory rule and made a decision. There was a challenge to this court on the basis that the decision maker had not exercised discretion and not considered all the circumstances.
Just tell us a little bit about what this was about.
A similar provision as to the undesirability of granting a person leave to remain.
This was to do with tax problems.
Yes. So a person, there was an allegation that a person had not acted with integrity. Yeah. There was a discrepancy in the figures that he had disclosed to HMRC and the figures that he had. Sorry. Yes.
Very similar background to Balajigari.
It is indeed. Yes. But it is an example of how the court applied Balajigari jurisprudence. Just one paragraph that I ask you to respectfully look at, paragraph 46. You'll see that this court allowed the appeal on a simple, straightforward ground, which was that there was no appreciation of discretion, no balancing exercise. In all but most cases where the conduct complained of is such that on any view the balance must fall against an applicant, a balancing exercise is required. And in my submission, in principle, the same approach applies to the validity requirements. In all but most extreme cases where the validity requirements are not met, the Secretary of State must still consider exercising discretion and decide how to exercise that discretion.
How does that work in practical terms? So the Secretary of State says, right, your application is invalid because you haven't got a certificate of sponsorship from the appropriate person, or your application is not valid because you're not actually studying full time at a university.
Yes.
What are you going to balance against that?
Well, again, an entirely hypothetical example, a student can say, for example, that, well, I wasn't able to continue my study because of the impact of COVID. that is the reason I wasn't able to complete my qualification by the date of my application.
If they don't say that
Yeah.
at the time when they make their application,
Yeah.
you're now saying that there's a Tameside duty to ask for an explanation?
No, I'm not. That's not my case. I was just giving an example that, that could be an example, a more clearer example where that applicant can say to the Secretary of State that, well, I don't meet the validity requirement because I wasn't able to complete my course because of COVID. You have a discretion. Consider my application on merits.
If they hadn't said it, let's suppose that there's no excuse, no, they just put in an application which on the face of it is invalid.
Yes.
I'm just asking you, how does the Secretary of State exercise the discretion? Are you submitting that the Secretary of State says, well, your application doesn't meet the validity requirement. There is nothing in your application that suggests that there are extenuating circumstances for this. As a result, I'm exercising my discretion to reject it.
But my submission is that, yes, that is what the Secretary of State says. Now, if the Secretary of State does not say that, and if there is a challenge by way of judicial review, and the applicant says that there is a failure to appreciate and exercise discretion, the judicial review court can entirely legitimately refuse to grant relief.
So if the Secretary of State says, you don't meet the requirements of the rules, I'm not considering the substance of your application, that's wrong. But if the Secretary of State says, you don't meet the requirements of the rules, there's nothing else you've told me that suggests that I should go on to consider your application, therefore I'm going to reject it, that's right.
No, that's not how. With respect, I'll put my argument that the submission is that if the Secretary of State fails to appreciate the discretion, then that is a public law error, and the primary issue before the court is whether there is a discretion in the rule or not. The Secretary of State says that there isn't. Now, if the court is persuaded that there is discretion under this rule, then in my submission, the court should adopt the course that is set out in the case law. Say that there is a discretion in the rules. The Secretary of State has not applied her mind to the discretion, and ask the Secretary of State to make a law.
Should we test my lady's point by coming to the case
yes,
in front of us, because that may give you the opportunity to to do a worked example of how this happens.
Yes. Yes, I mean,
Oh, sorry, I didn't mean to cut you off, but
no. I mean, these are the submissions that I wanted to make on the law. I mean, I have given you examples.
was there anything else on the law?
No,
Because I
no.
think very
So
clear what
these
you're
are my submissions on the law. On the facts, of course, I wish that I had a case involving the sort of examples that I was giving you. A student unable to complete the course because of the impact of COVID, a visitor unable to return because of war. But before you look at the facts, I'll make the submission that if the court concludes that there is no discretion under the rules, that would include all sort of cases. Now, just looking at the facts of this case.
Well, it's not. We're not being asked to conclude that there isn't a discretion. We're being asked to conclude that there is no obligation to give further consideration to an invalid application.
Well, I'm not, with respect, entirely sure if that's how Secretary of State has put the case, and that's what the Upper Tribunal said. My understanding, of course, you'll hear from learned friend, is that where the validity requirements are not met, the Secretary of State says that, well, an application must be rejected. There isn't a discretion.
No, that's not what anybody has said. It's essentially up to the Secretary of State. That there's no obligation on the Secretary of State, but she has a liberty to act in a certain way. If one was to consider, for example, an example where instead of paying £979, somebody had missed, hadn't got their glasses on and paid £976. Then that might be thought to be a de minimis case in which the Secretary of State might be said to have an obligation to reply and say you appear to have got the check wrong or whatever it is. So that might be an example where
Yes.
the Secretary of State could exercise some latitude,
Yes.
but I don't think it's being said that they're obliged to refuse.
Now, if, Lord, of course, you'll hear from Leonard, and I may have completely misunderstood the position. Now, if the Secretary of State accepts that she's at liberty, as my Lord puts it, she's at liberty under the relevant rule to act in a particular way, she's at liberty to consider an application, then that is my case. This is all that I was seeking to establish, that she's at liberty to do this. She has a power, she has a discretion.
The trouble is, I think, Mr. Malik, that your formulation involves a conscious decision and an explanation of it,
Yes.
that they are not going to consider it on the merits. Whereas I think that Lord Murray's position for the Secretary of State is, I've got a power to reject this out of hand because it doesn't meet the rules. I exercise that power. It's not the same as exercising a discretion in the sense of a substantive discretion, and that's exactly what I've done. I've told your client that he attempted to make an application. He doesn't actually fulfil the requirements of 15, and therefore we're not going to consider your application any further, and that's not an error of public law. It's applying the rules.
Well, lady, if this is what my learned friend says is the Secretary of State's position, then that is not, with respect, very different to the submissions that I've made so far.
You see, your key word to my ear is obligation. You are imposing an obligation upon the Secretary of State, where the Secretary of State, for her part, considers that she has a power or a liberty to do something. And those two things are different.
Well, yeah, if the Secretary of State accepts that she has a power, she is at liberty to do that, then the failure to appreciate that she's at liberty to do that would amount to a public law error.
We were coming to this particular case where we appreciate that your client, as it were,
Yes.
had the rug pulled from under him by the changes in the
Yes.
in the rules.
Yes. So, Lord, on the facts, may I just show you first the certificate of sponsorship
Yes.
document that appears at page 76 of the bundle. This is a document that you'll see was issued on 16th of June 2023. The date is at page 76.
It's about a month before the rules change.
Yes, a month before the rules change. And you'll see that the job is offered as a care worker.
Yeah.
Now, this was issued on 16th of June 2023. The appellant could have made an application on 17th of June with that certificate of sponsorship. If he had made the application on 17th of June, the application in all likelihood would have been granted. The validity requirements were met, all suitability requirements, eligibility requirements are plainly met. Now, can I, just take you back to the authorities bundle just to show you how the rules changed between the date on which the certificate was issued and the date of the application. So the relevant statement of changes in the immigration rules, HC 1496, is behind tab 2 of the authorities bundle. Now, you'll see that this statement of changes was laid before Parliament on 17th of July 2023.
page 65, isn't it?
Yes, but before you look at page 75, if you perhaps just look at page 54, which concerns implementation, and you'll see that it says that the following provisions shall take effect on 17th of July at 3 p.m. So on the same day as the statement was laid before Parliament, it took effect.
And to the third bullet point.
Sorry?
Third bullet point.
Third bullet point, yes. And that, as Milady pointed out, appears thereafter at page 65. And now it is, as I pointed out in my skeleton, it is unusual for the statement of changes to take effect on the same day.
Usually 21 days, isn't it?
Absolutely. So there is a parliamentary convention that the immigration rules, as laid before Parliament, take effect no earlier than 21 days after being laid before Parliament. Of course, the objective is that enables Parliament to scrutinize the relevant immigration rules and to decide whether there should be a negative resolution to disapprove them. But here, the rules took effect without any notice and on the same day. So that was a departure from the parliamentary convention. That does not render the rules unlawful, but in my submission, that is of some relevance. And the departure and the abrupt introduction of this provision placed the appellant in a significantly detrimental position.
You say it's relevant. In what sense is it relevant?
On the issue of discretion.
But it can't be relevant to a discretion that doesn't exist, and it might be to a discretion that did exist.
Well, yes, if there isn't, so if the Secretary of State has a power under SW 1.6, or if she's at liberty to do something, then in my respective submission, that can be a case where the Secretary of State can legitimately say that, well, your certificate was issued.
If there was a discretion, yes.
If there is a discretion, of course, yes. If there is none under the rules, the claim fails. But if there is discretion, then that is a matter of relevance.
She can't be criticised, even if there's a discretion. She can't be criticised for failing to take that into account if that particular point isn't raised to her.
Well, yeah. Well,
if there's no Tameside duty to make inquiries, and you've accepted there's no Tameside duty.
No, there is certainly none. But I showed you, Milady, the certificate of sponsorship. So the Secretary of State knew that the certificate was issued on 17th of June 2023.
Well, only if she considered it.
That's true.
Well,
Which she wasn't obliged to do on any basis.
well, but of course that is the issue in the appeal. So my
No, your argument is, was she obliged to considering it?
yes, the application and my the submission that I seek to put forward is that firstly there is a failure to appreciate that there is a discretion, but a lawful decision maker would have looked at the certificate of sponsorship, looked at the facts and decided.
Well, that's the point I put to you earlier. It doesn't seem to me that you can exercise the discretion you say is there without considering the applicant.
Well,
So it sort of slightly rewrites the rule, doesn't it?
Yeah, you can, in my respective submission, entirely legitimately look at the application without deciding whether suitability and eligibility requirements are not met, just to see whether there is something that justifies exercise of discretion in the appellant's favor.
I do wonder, and I think we're entitled to ask you this: where does all of this go?
I think we've come to that. Yes.
Because I understand you want us to say that permission should be granted and there should be a judicial review.
Yes.
But where at the end of the day is this going to go when there's nothing put forward, or was nothing put forward?
But
should mean that the Secretary of State would have exercised the discretion in favour of your client.
But yes, well, of course, if you take the view that there's simply nothing in the case that may justify exercise of discretion, the outcome is inevitable. You'll refuse the application or dismiss the appeal on that basis. But what I'm seeking to establish is that this isn't a case where the outcome is inevitable. The facts are such that a decision maker may legitimately admit the application.
Could we come to this again in a moment? I just wanted to. There was an explanatory memorandum with the rule change in the usual way.
There was, yes.
Yes, and I mean, I'm just for in case there's anything you wanted to say about it, it's at paragraph 6.5 to 6.7 of the memorandum. I can't remember whether we've got it in our papers or not, but it basically just notes the convention, explains why it's being departed from.
Yes.
To reduce the possibility of a large number of applications for defendants and switching being made in the 21 days, which is obviously
Yes.
why that was so.
Yes, I don't have the explanatory memorandum, but if it says that the intention is to reduce the applications,
reduce a large number of applications within the 21-day conventional period.
Excuse me.
well, yes. Well, I'm sure it does not say that the intention is to exclude such applications completely. So it may well be that the intention was to reduce the number of applications, but not to exclude applications completely. But of course, you, as I sort of demonstrate, that you of course must, with respect, focus on the language of the rules. I may.
No, we were
be wrong. Yes.
We're putting the rules in their context as we're obliged to do.
Yes.
Not just looking at the paragraph, but looking at the section and then looking at the rules as a whole, and the intention behind them. But so, was there anything else that we needed to think about in relation to the, as it were, the parliamentary transit?
No, that's all. Yes.
Yeah.
So can I just show you the decision now? The decision that is being challenged. That decision is at page 74 of the bundle.
Sorry, 74, did you say?
Yes, 74 of the appeal bundle. You see that this is, of course, a template decision.
We're looking at Judge Smith?
No, page 74. This is the Secretary of State's decision. Page.
Sorry, the pages don't match. Yes, it's a.
Quite close to the end.
Yes, I've got it. Thank you. I feel great sympathy for the recipients of letters that look like this.
Yes. So you'll see what the
I
letter
mean
says.
for the result, but just simply for the quality of the drafting.
Yes. So your application is rejected as invalid, will not be considered, and then the Secretary of State has quoted the rules. Now I would respectfully invite. Yes.
Will not be considered for the reasons set out below.
Yes.
You must meet the appendix skilled worker validity requirements. We have noted your current course expected end date is 2025.
Yes.
That's part and parcel of the reading, the ruling before quoting the rules, isn't it?
Yes. Of course. Yes. Yes. But what I would respectfully invite Milady and Milords to do is to judge whether there is a public law error in this decision by reference to the formula that appears at paragraph 12 of UCAS, the paragraph that I've just taken you to. Whether the Secretary of State has recognized the part of the immigration rules that she was applying. Yes, she has. B, whether there is an acknowledgement that this involves him an exercise of discretion? No,
Why?
because there is by acknowledgement, what the Upper Tribunal meant was that the Secretary of State saying something to the effect that I appreciate that I have a discretion.
Yes, I think we're going back, and it clearly doesn't say that. So we take that point.
Third, whether the decision has identified the factors to be taken into account in deciding how to exercise discretion. No, one of the factors in my submission would be the abrupt changes in the immigration rules, the fact that the certificate was issued a month before the changes, the fact that the applicant, if he had made an application before that date, would have qualified. The fact that he met all other relevant requirements, save as one particular requirement. So these are, in my respective submission, matters that fall in the appellant's favor. I do not submit that those factors mean that the Secretary of State is bound to accept the application as a valid application, but those factors fall in favor of the appellant. And then whether there is a balancing of those factors against one another. So the factor against the appellant would be that, well, there is a rule, and the rule is there for a purpose, and the rule is expressed in the way it is. And then whether the balancing exercise results in a reasoned conclusion. That would be a classic example of a lawful exercise of discretion, but my submission is that you don't have that sort of exercise here.
Thank you.
And finally, the last document is the Upper Tribunal's decision refusing permission to apply for judicial review. That decision is at pages 28 and 29. And it may well be the case that I'm simply misreading paragraph 4 of the judge's decision. This is where the last sentence of paragraph 4, the applicant's interpretation of that provision as including a discretion to treat an invalid application as valid is not arguable. So the Upper Tribunal refused permission, saying that, well, there isn't a discretion under the rules. And that is really the target of this appeal, that there is a discretion which wasn't really exercised. And that is the ground that I seek to pursue. The second point that is made, and if you are persuaded that there is merit in the submissions that I've made, you will conclude that paragraph 4 is wrong in law. Now, paragraph 5 says that there's no irrationality, but this isn't an irrationality challenge. We are not at that stage, because in my submission, we were rejected on the basis that there is no discretion. So if my learned friend, as Milady and Millards were putting to me, if my learned friend accepts that there is a discretion under the rules, then he will have to accept that the final sentence of paragraph 4 is wrong. And my understanding was that my learned friend is seeking to defend that particular part of the decision. There is a reference to Bihari and Ullah.
Do you mind if we go back to paragraph 4 just before you move on? The first sentence, I'm just trying to match the first and last sentences of paragraph 4.
Yes.
To see what is being said and to see whether the same thing is being said at both points.
It is. So the rule does not permit the Secretary of State to do anything. Just to use the language that Millard was putting, there is no power to do anything else. The Secretary of State is not at liberty to do anything else. There isn't a discretion, and that is the target of the appeal.
And then the second sentence.
What it does is permit the Secretary of State to treat as invalid.
You say that engages a discretion.
The second sentence.
Yeah.
Yes, yes. I mean, of course, yeah. So if it permits the Secretary of State to do something, that is, I'm entirely content with that. That means that there is a discretion.
She can or she can't, and that she has to deal with that can or can't in the way she deals with any decision,
Yes,
namely by exercising lawfully exercising that discretion.
yeah. That's how I put my case.
That's all it comes down to.
Absolutely. Yes, absolutely. Unless, of course, you are persuaded that by Millennium's case or by the Upper Tribunal's analysis that there is simply no discretion. It's a mandatory.
So we need to look at paragraph 4 carefully.
Yes. Paragraph 5 it concerns a rationality challenge, but
Yes,
this
and you-
isn't a rationality challenge. We are not, in my submission, at that stage. But there is a reference to Bihari and Ullah. And I will not take you to that authority now. Millennium may take you to it. But that was a case where the mandatory, not discretionary, mandatory requirements of the rules were not met. A student was not able to qualify under the rules because the relevant requirements are not met. And the court essentially said that, well, where the mandatory requirements are not met, the obligation to consider exercise of residual discretion outside the rules would trigger only in 2 circumstances. First, where an applicant expressly invites the Secretary of State to depart from the immigration rules in the exercise of residual discretion. And secondly, where the facts are so striking that it would be irrational for a decision maker not to depart from the immigration rules. But that is not this case
It
because
sounds a bit closer to this case than some of the cases that we've been looking at so far.
well,
No.
in that case, I'll take you.
Well, yes, I mean, I think we need your help with that. If
Thank you. So Bihari is tab 5 of the authority handbook. Now, if you look at paragraph 3 of the judgment, now where the relevant rule is set out, and again, you'll immediately see the difference. To qualify for leave to remain as a student, an applicant must meet these requirements. If the requirements are met, leave will be granted. If the applicant does not meet these requirements, the applicant will be refused.
So it's just like the paragraph that you took us to.
SW 1.7, yes.
17.1, yeah.
So the difference here is that the rule that we are dealing with uses the word may. Make the point that, well, the Secretary of State could have said will in the relevant rule, and that would have made it absolutely clear that there is no discretion. There is no power. The Secretary of State is not at liberty to
so
do
this
anything.
was the issue there was, as we can see, is a decision had to be made about whether the applicant had an established presence.
And the court concluded that the applicant had no established presence, so the
Okay.
requirements of the rules were not met. That meant that the Secretary of State was under a duty to refuse the application.
And the use to which Bihari was put by the parties in the UT was what? What part of it was?
Now, there were two separate grounds in Bihari. The first was about construction of the phrase established presence. The appellant said that, well, the requirements of the rules are met. The court disagreed. The second ground was that, well, even where the requirements of the rules were not met, the Secretary of State should have departed from the immigration rules in the exercise of discretion outside the rules. So the paragraph that is relevant is paragraph 39, page 183. So even where there is a rule that is mandatory, as I said, in 2 circumstances, there would be an obligation of the Secretary of State to consider departing from the rules. First, where there is an express request, and secondly, where the facts are quite striking. But I say that is not this case, because, I mean, if the validity requirements were phrased in the same way as this rule, if the validity requirements had used the word will, And if the Secretary of State had then rejected the application as invalid, we would then have been in this territory.
Right.
But it is not this case, because the rule use the word may as opposed to will.
Thanks for your help with that.
Yes, I'm very grateful for your patience, my lady, my lords. These are my submissions.
No, thank you very much, Mr. Murray. Yes, Lord Murray.
Thank you, my lord. Just on that last point, if it's just my lord's note.
I'm very sorry. Mr. Malik sat down before, but I had something I wanted to ask him.
Oh, I'm so sorry.
Yes.
Yes.
It was really to go back to my Lord's question, which I had mentally parked earlier on, which was, what good is this to your client?
Yes.
I mean, I can quite see that he may want to do a good deed in relation to the rules, but is there anything that you could say that would suggest that he has actually any benign interest in this? Is there any outcome for him that works?
Well, of course, and that is the reason why I'm here. So
Well, exactly. So how does it work? Just explain to us how, if we were to say, well, there is, yes, indeed, under 1.6 a discretion here that the
Yes.
Secretary of State fails to appreciate. How does that advance his case in any way?
Well, of course, this is an appeal from a refusal of permission to apply for judicial review.
Right.
And the first question from Milady and Lords is whether what I'm saying is arguable.
Well, no, because
You've heard-
by this stage, it's a
Yes,
point of law,
yes.
and we're going to decide it.
Absolutely. So, if you are persuaded with the submissions that I've made,
Yes.
what in my submission you will do, or you can do at least, is that you will set aside the Upper Tribunal's refusal of permission to apply for judicial review. You will then, exercising the Upper Tribunal's function, grant permission to apply for judicial review. If you are persuaded that my submission has any merit, exercising the Upper Tribunal function, you will then grant the judicial review claim.
Right. What
And you will
what
quash-
I was wanting to
Yeah.
bottom out was what possible basis we would have for granting permission to apply for judicial review in this case on these facts.
Well, yes,
I mean, do we go back to the fact that if the law hadn't changed, he might very well have had a good case? Is that it?
well, there are other factors that I highlighted. Of course, the first being, as my lord pointed out, an abrupt change in the immigration rules that prejudiced his position. Second, that you may take the view that it's the same point, but the second, that the certificate of sponsorship was issued a month before the change in the rules. Third, that he is seeking leave as a care worker, a role that appears on the shortage occupation.
But this is the same argument as didn't work for you in Bahari. I mean, there isn't a near miss in this area.
No, but of course, what I'm sort of seeking to submit with respect to my lord is that where the rule is mandatory, those sort of arguments would not work unless there is something really compelling or exceptional, or unless an applicant expressly asks the Secretary of State to exercise discretion outside the rules. But we are not in that
So,
territory.
but, I mean, effectively, you have to make a case that it was unlawful. I mean, you have to get past the discretion point, and having established that there is a discretion, you then have to establish that it was unlawful for the Secretary of State to exercise it, not to exercise it at all,
Yes.
to have reached the conclusion that they did, and you would have to get over the threshold of Section 31(2)(a), wouldn't you?
Lord,
Even if there was unlawfulness.
Lord, the way I would respectfully invite my lord to approach this matter is this, that you conclude whether there is a discretion, whether the Secretary of State has appreciated, exercised that discretion. If no,
Yes.
then it is for the Secretary of State, in my respectful submission, to persuade you that the outcome is inevitable. There is no room for a different outcome, or it's highly likely that the outcome would not be substantially
No,
different.
I suggest that you have to go back to a previous stage, which is you've got to put up some case
Yeah.
on the facts that could possibly have entitled you to relief by way of judicial review. At the moment, I'm not seeing what those could possibly be. I mean, it's, I'm just giving you the opportunity to address that, because as I understand, your point is a generic one, namely that the rules changed and that he didn't get his application in before they changed.
Lord, of course, it's not in my submission an entirely generic point. Lord, so these are really the factual points that I can realistically put forward. That the fact that the rules changed after he was offered a job, after he obtained a certificate of sponsorship. Secondly, there was a departure from parliamentary convention. No notice as such was given. He meets, in my respectful submission, all substantive requirements.
But he's in exactly the same position as everybody who's applying, who is caught out by the rule change being not giving the 21 days notice.
Well, everybody who was offered a job before the change in the rules,
Yes.
was issued with a certificate of sponsorship before the changes in the rules.
Which is precisely why that was the precise intention of not giving 21 days notice, wasn't it? So that people in that position would not qualify.
Well, the intention in my submission would be to reduce to reduce the application. If it was, I have no difficulty with that. But these are the points that I can.
Well, I didn't mean to harry you about them. I just wanted to make sure that there weren't other aspects of this which, in a sense, you laid aside for another day. I mean, we've looked at this and can obviously see what the situation is, and that's what you would rely on in suggesting that the court ought to. This court ought to grant permission and indeed grant judicial review. Yes, and perhaps just one final point again, addressing that particular concern that, my Lord, you have. You'll recall that I took you to Yasin, where the point was made that in all but extreme cases where there is a discretion, that discretion must be appreciated and exercised. This is how, in my submission, the courts and tribunal has thus far approached the discretionary provisions. Now, if there is a failure to appreciate and exercise discretion, in my submission, the Secretary of State, as the authorities tell us, should be required to make a lawful decision. And there is a possibility, a prospect that the Secretary of State may, if she appreciates that there is a discretion, may exercise that discretion ultimately in the appellant's favor, considers the application and grants it.
Well, that doesn't undermine the general approach to judicial review that where none of the factors mentioned would have made any difference to the decision. You wouldn't grant judicial review.
Yes, I mean, if you take the view that, well, it makes no difference on the facts of this case, you'll refuse permission, you'll dismiss the appeal. But you say it's possible that possible that it might be granted nonetheless. Yes, that's how I put the case. Yeah. Thank you. Very good. Yes.
Thank you. Clearly, the court have explored many of the areas which would be the subject of the respondent's submissions, but perhaps it's important to set in context the purpose behind this rule change. As was correctly identified by Upper Tribunal Judge Pickup, we just turn to his decision on the papers, which is in the appeal bundle, at page 26 and 27. So this was obviously when the judicial review was initially lodged. there was a decision on the papers following consideration of the acknowledgement of service. And at page 26, paragraph 4, Upper Tribunal Judge Pickup refused permission and set out his reasons. And at paragraph 4, he noted that under Rule SW 1.5a, a student must fulfill one of 3 conditions. And then noted those rules applied as from the 17th of July 23, effectively closing the route except for students who had completed their courses, and was made as part of the government's efforts to prevent abuse of the student route being used for the purpose of work in the UK. And in that statement, Upper Tribunal Judge Pickup was entirely correct as to the purpose of the rule change. This appellant had arrived in the United Kingdom on a student visa valid from the 11th of January 2023 until the 30th of October 2025. He had done about 6 months of the course, long prior to the completion of the course, when he was assigned his certificate of sponsorship. It's clear that the purpose of that certificate of sponsorship, could I just invite the court to look at page 76. Was to work as a care worker. We can see at page 77 the name of the employer and the role that he was to be performing by the lower hole punch hole, and the net salary that he would have been paid. And he made the application, which we see at page 79. And while we're here, my lord, you'll see the fee is by the top hole punch hole.
Thank you.
Total fee £979. And he set out the purpose of his application. So this was a classic switching scenario from student to skilled worker. And he was to work in a care home. And he, at page 82, notes that he'd lived in the UK for 6 months by the date of the application. I just invite the court to turn over to consider page 84 and 85. They're very standard. The answers are generally given there, and there is nothing personal or no application for any particular exceptional treatment or any complaint about the date of the introduction of the application. And I just note before we leave the document that you will see the top on page 79, just above where we have the fee, the date and time of the application is noted of the 20th of July. The application, as my learned friend noted, received the response that we have at page 74 and 75, which is the email from Home Office at us. And as my Lady Justice Andrews noted, it's largely a template document. However, it does, in the first 3 paragraphs, say you have attempted to make an application for permission to stay. Note the word attempt, which is consistent with the questions posed by my Lord Justice Phillips, in that this was an application which is being regarded as invalid. That then is consistent with what's in the second sentence. Your application has been rejected as invalid and will not be considered for the reasons set out below. And the reason set out below is that you don't meet the validity requirements and the 3 categories set out in SW 1.5a. And the particular reason is set out as my Lady Justice Andrews noted. We have noted that your current course expected end date is 2025. And that, of course, is the reflection of SW 1.5a, which requires the course to have been completed prior to the switch. So,
Right, so he didn't comply with A for that reason, and he wasn't in
And
Either of the streams of B or C.
correct, he wasn't a PhD student, and he wasn't. He didn't fall within the category of B(2), which must have a start date no earlier than the course completion date, which effectively amounts to the same thing as in these contexts. And it's also perhaps of note that in the extract from the rules that the decision maker included, SW 1.6 is included. I mean, ideally there might have been a space after 1.5, but it is recited. An application which does not meet the requirements, etc., is set out. And then I would just draw your attention, as my lord, you noted, the practice on page 75 in the final paragraph, you will receive a refund of the fee you paid minus a £25 administration fee. If you paid the immigration health surcharge, that too would be refunded. And it seems to me that goes to the point that my Lord Lord Justice Phillips raised, which is the second part of 1.6, that an application would be invalid and may be rejected and not considered. And if an application is not considered, then you get your fee back. Given the size of some of these fees, that's quite a considerable thing. It's very different. And perhaps during the course of Millennium Friends submissions, there became some elision of the terms rejected or refused and rejected as being invalid. And it seems to me they're two very different things, and they certainly, the respondent certainly regards them as being very different things. That then
Rejected, you say, is rejected on merits.
yes.
Sorry.
They're refused.
Refused.
Sorry, refused on merits. Forgive me. Yes, absolutely. Thank you. Just then, so when the judicial review application came in, it's perhaps worth just clearing up one anomaly that arose when we were discussing Bahari a moment ago. There were a number of grounds advanced, and obviously Millennium Friend wasn't instructed at that point. But it's worth perhaps just considering the grounds that were before the permission judge. And they're at page 72 of the appeal bundle. So there's an amended set of grounds that begin at page 70, and the grounds themselves are at page 72. And the suggestion was, this was the submission that was being considered by the permission judge, whether in the circumstances of the case the respondent was obliged to consider whether to waive the validity requirements at her discretion. She failed to do so and accordingly acted Wednesday unreasonably, and then relied on paragraph 39 of Bahari that the court looked at a moment ago. And it's that which triggers, I suggest, the response in the decision, the reasons given by Upper Tribunal Judge Smith, which we'll see in a second.
Well, that's the subject matter of paragraph 5, isn't it? The decision.
Forgive me, yes, paragraph 5.
Which is the alternative to paragraph 4.
The decision itself, made by Upper Tribunal Judge Smith, is obviously a decision following a hearing to refuse permission. It's not a fully reasoned judgment, and it sets out a basis for his decision, and it's clear that there is some elision between the points made in paragraphs 4 and 5 because of the way the grounds were put. I suggest, however, that what is at its heart correct is the contention in paragraph 4 that the wording in SW 1.6, where the Upper Tribunal judge says what it does permit is the respondent to treat as invalid without consideration rather than refuse an application which does not meet validity requirements, is a correct
Well, so
interpretation.
you seek endorsement of the or the second sentence of paragraph 4. Is that?
There's no obvious. Indeed, I do. There's no obvious tension between that and the first sentence. The learned judge was correct to recall that it doesn't arguably permit the respondent to treat as valid in her discretion, because for the reasons that the court have already explored in submissions with my learned friend, it's perhaps of note, in considering that this is an appeal against the exercise of permission, that even if that were not the case, Employment Tribunal Judge Smith then considered the alternative, and I would draw the court's attention particularly to the sentence beginning, "It is not arguably irrational for the respondent not to exercise a discretion."
Yes.
And the judge must have been right in saying that for the reasons we've already looked at, in that there was no basis upon which that discretion could have been exercised.
Well, could you have a? We can obviously look at documents. Whether you're commenting on the Upper Tribunal or Mr. Malik's submissions, or referring to your own skeleton argument, could you just clarify for us, without maybe reference to document, what it is that exactly the Secretary of State's case is in relation to 1.6? What does that mean in terms of the range of possibilities? Namely, Mr. Malik says there's an obligation to exercise a discretion. The Upper Tribunal judge seems to think that you don't have any, first and last sentences might be read as suggesting that you don't have any discretion to exercise at all, or there may be an intermediate possibility of some kind.
Yes, so if I might take you to my skeleton argument, perhaps in breach of the...
No, not
the
at all, but
injunction not to
if you're
refer to
happy
the
that
document.
as it has its, in the way you'd like to put it, that would be helpful. So this is the separate skeleton argument.
Yes, so the respondent skeleton argument at paragraph 12 on page 4, obviously it's our submission that paragraph SW 1.6 intentionally created the conditions precedent for valid applications, and the intention was to close the route for students, the submission that I've already made. The purpose of the may in that context is to permit consideration as described by Upper Tribunal Judge Smith, that where it didn't meet the conditions, this is 12(2), where it did not meet the conditions precedent because he had continuing leave as a student and didn't fall into the conditions in SW 1.5a, then the Secretary of State has a discretion, and this is the top of page 5, didn't arguably permit the Secretary of State to treat as valid in her discretion an application which was invalid, but instead provided a discretion to reject as invalid without consideration.
Yes. Well, I understand the last proposition, but I'm wondering whether the word permit, as used by the judge and taken up by yourself in that paragraph, it shouldn't be, to reflect what you're submitting, be understood as require. The Secretary of State to consider. I mean, I'm not at the moment quite seeing. He appears to be saying that it doesn't allow you in any circumstances. That would equate to, as I understand it, must.
No, I agree with you, my lord, in that regard.
And you're not arguing for must.
No, I'm not arguing for must. It does say may.
Yes.
But the effect of that is not to afford a discretion. It's the question that Lady St Andrews summarised rather pithily in the course of exchanges with a learned friend. The purpose of it is clearly, as we have considered, and indeed it has to be viewed in light of the overarching submission that I set out in my skeleton argument in relation to the case of Hippolyte, which we put at paragraph 19 of the skeleton. Now, in that case, obviously, we refer to the overarching discretion that must exist within the rules. And it's worth perhaps looking at the case law in this regard, because it seems to be that the may in the rules is intended for a very particular set of circumstances, but not to give rise to a discretion.
Isn't that a rather long-winded, if you'll forgive me, way of saying that may means you have the power to do something? In other words, may is being used in that context as the Secretary of State is empowered to reject this out of hand without considering the merits.
Well, you can take out the out of hand and or considering the merit, but you have the power to reject without consideration.
That's exactly right.
Isn't that the
Yes.
the straightest road to what I understand the Secretary of State is saying? And the fact you have a power doesn't import that you are obliged to use it in favour of an applicant. You've got a power to do it, and no doubt, unless you're presented with something fairly exceptional, that's what's going to happen.
Exactly, and that is the position that is consistent with the case of Bahari that my learned friend mentioned.
But that's outside the rules.
Well, can I just? There's a general observation which I think is of application here. If I could just invite you please to turn to tab 5 in the authority file, which is Bahari. In the decision of Justice Burnett, at paragraph 27 of page 181 of the authorities bundle, there was an invitation. You obviously were taken through the facts a moment ago. There was an invitation that the Home Office could have been expected to approach the reference in the claim form to section 55 in a way that afforded a discretion. And the court goes on to note that applicants for leave to enter or remain in the United Kingdom make their applications, and the Home Office considers and decides the application made. It cannot be expected to chase shadows. At no stage did the applicant explain what the consequence of proper consideration of section 55 would be. And obviously we're in a similar situation with the submission that my learned friend makes in this case.
Well, that goes to the merits, really,
Yes, I
rather
agree.
than to the point of construction. I mean, I think before we get to that, the real question is, what does may mean in this context?
Well, as I'm entirely comfortable with the understanding of the purpose of the word may in SW 1.6, as identified by my Lord Justice Peter Jackson.
The difficulty is that the submission against you is, Mr. Malik says, well, there's remorseless logic here, that as soon as you have a power to do something, that involves a choice. You choose to exercise it or you choose not to exercise it. And as soon as you have that choice, that is a discretion. You can either do it or you can't do it. And as soon as you have a discretion, you are then straight into all the law about the fact that if you've got a discretion, you have to exercise it and you have to say you've exercised it. And I think what all that Mr. Malik says is, yes, I accept you have a power to do this, but that means you also have the power not to do it. And therefore you have a discretion, and that's it.
So it was to address that question that I wanted to take the court to the case law in the case of Hippolyte, which we have at page 184. So this is a case, a comparatively recent case, concerning the Windrush compensation scheme and the Windrush visa scheme more generally. In Hippolyte, there was a question about the consideration as to whether there should be discretion exercised. And the discussion of whether the discretion should be exercised is, I suggest, instructive in the context of this case. If one looks at page 192 of the authorities bundle, Mr. Justice Sheldon rightly observed that a public law decision maker can't fetter their discretion, and then set out the well-expressed principles in the West Berkshire District Council case from 2016. And in paragraph 17 of the quotation, you'll note that the Court of Appeal noted that a policymaker, notably in central government, is entitled to express his policies in unqualified terms. He is not required to spell out the legal fact that an application of the policy must allow for the possibility of exceptions. I don't think that's a controversial public law principle. The Court of Appeal goes on to quote De Smith on the point. As a consequence, the judge in the case of Hippolyte, which we turn to page 193 at paragraph 30, goes on to say that the question was whether the Secretary of State had applied those principles in refusing the claimant's application for indefinite leave to remain under the Windrush scheme. And reverting then to the point from my lady a moment ago, how does this assist us with the interpretation of the May? The point is, there is no need for the immigration rules to include a reference to the express ability for the Secretary of State to depart from the rules, as you explored with my learned friend a moment ago. And as a result, there can be no criticism that the rules are structured in the way they are. And it does afford a sufficient flex in the system, as my lord, you correctly observed, to allow de minimis matters to be taken into consideration when deciding on the appropriate step to be taken.
Forgive me, are you? But the fact that there is and there must be a discretion outside the rules doesn't help us, does it, with whether there's a discretion within the rules here? And I think the major difference is, and I accepted this, that if it's outside the rules, then it's got to be raised or it's got to be obvious. So that's something so dramatic that it's obviously has to be taken into account. But if it's inside the rules, the Secretary of State can only make their decision by exercising the discretion. That's the point, which is why the point that's been put to us very forcibly today is as soon as you say someone may do something, the Secretary of State is immediately within the discretionary realm, and they then have to exercise that discretion.
The problem with that line of argument is, I think, the point that was put so powerfully by the court to my learned friend a moment ago, that on the one hand, I think Justice Andrews put it most recently, that Mr. Malik appears to be saying, well, if the decision had included a formulaic sentence, a form of words which said, I have a discretion under Rule 1.6,
and there's nothing here,
and there's nothing here, so I'm not exercising it, then he would have no complaint, and that would meet his challenge.
It's the law, though, doesn't it?
But then the answer is, I think, that which was raised by Lady Justice Andrews, which was, well, then you just say on Wednesday reasonableness grounds or a reasons challenge that your reasons aren't sufficiently detailed. And so what the Secretary of State is keen to demonstrate is that there's no point in having repeated formulas of forms of words to go into decision letters simply to meet potential challenges on the basis of a non-exercise.
The Secretary of State put into her policy then that the application must be rejected. that's what she wants to do.
If
It's her policy. She
it's
can
her
say-
policy,
If she wants to say that if the validity requirements aren't met, the application must be rejected or will be rejected is probably the more sensible language, then she can say so, but she hasn't. This is something she knows is going to be read by decision makers.
the experience of the.
I'm sorry.
So, forgive me, my lord.
I must let you
I
answer
can entirely
something.
see. I can entirely see where my lord is thinking this through, and why my lord's doing so. The Supreme Court in the tangential relevant case, which I put into the bundle, which I think the court should see, is the case of Afsal, which concerns Section 3C leave, and in the context of that case, forgive me, it's.
So this is validity.
10 years.
At tab 3 of the bundle. Now, this is, of course, a decision from June 23 itself, and as you'll see from the headnote, concerned the question of the litigation about whether or not there was a general discretion outside the rules, and the court contrasted the case of Afsal and an earlier case of Mirza, and considered whether or not the strict a mandatory rule in a statutory instrument was as flexible as those in the rules. And the conclusion generally is that the rules contain an inherent discretion, whereas there's no discretion in a statutory instrument of the type we see in Mirza. And of course, that goes back to the point about the general discretion, and the point that I failed to highlight about the relevance of the general discretion is that if there's a general discretion, then the need for the may to imply a discretion, as my learned friend seeks to argue, it seems to me is ameliorated in any event, because you can always have the option in an exceptional case of granting leave outside the rules. So that therefore means that the basis for my learned friend suggesting that the reason for the may to mean a discretion was that it should be there for contingent circumstances, setting aside the merits of his own case.
Well, what about the distinction between 17.1 and 1.6?
Yes, it would be of assistance, I think, to the court to look at the statement of changes itself. If I could take you to tab 2, the statement of changes, and this perhaps answers a point that my Lord Justice Jackson put to a learned friend. At page 65, the changes to Appendix Skill Worker, we can see that after SW 1.5, SW 1.5a is inserted. And one part of 1.5a that we haven't, my learned friend didn't highlight perhaps, was that in 1.5 itself, the requirement to fulfill the conditions, A, B, or C, is a mandatory one. So you must fulfill one of those requirements. That, of course, is then inserted ahead of SW 1.6. So the court will have to construe what's said in 1.6 in light of its statutory context, which is that it's preceded by this mandatory provision. And that, I suggest, feeds into what the court should read into the may in SW 1.6 and favours the interpretation adopted by the Upper Tribunal Judge Smith when he refused permission.
If the wording used had been will normally reject, you'd accept that would have been discretion.
Well, the difficulty is there you're getting back into the rejection refusal argument. If one does, then we just return to tab 1 and to the rule page 8. So what my lord posits is if SW 1.6 read an application which does not meet all the validity requirements for a skilled worker will normally be rejected as invalid. So that would in the context coming immediately after SW 1.5, would I suggest not in the context in the same way as the may doesn't imply a discretion, but there is, I'm loath to argue the hypothetical in that context because there are, as my learned friend has identified, a number of cases on the wording would normally be.
Well, if it says will normally be rejected, that it seems to me implicitly or maybe even expressly anticipates a decision as to whether it's will be treated as the norm or whether it will not.
I would be less comfortable arguing for the contention that it doesn't contain a discretion than I am in the present.
Yes, I mean, I'm sorry, I beg your pardon.
Well, can I just finish off the
Yeah,
point?
no, sorry.
Just simply, but the difficulty, it seems to me, is that on the face of it, may is more permissive, more discretionary than will normally be, which at least contains a presumption, whereas may doesn't even contain a presumption.
I see why my lord says that, but I would suggest that it's submitted that the may in that context must be read in the context of the whole sentence. And if one reads it in the context of the whole sentence, it's more limited because I draw the court's attention particularly to the does not meet all the validity requirements. So the all there is significant, and may be rejected as invalid and not considered. The may, of course, the verb there applying both to the rejection and to the non-consideration, as the court correctly observed earlier. And in so doing, it qualifies the meaning of the may not just to be a general may, which would afford an open-ended discretion.
And you are going to come back to the difference with 17.1.
Certainly. So obviously in the structure of the appendix skilled worker, as my learned friend rightly pointed out, we have the validity requirements, some of which can be fairly, well, they're all procedural. And then we have the eligibility requirements, which obviously relate to something that will be considered during the course of the application. And at page 31, we can see that the test that's going to be applied by the decision maker is set out, and that's doing a different job because it's saying what the test will be on consideration of the application itself. So, and that's why will be refused as the appropriate default. Obviously, if you don't meet the eligibility tests, your application will be refused. And it's interesting that I submit that the administrative review provision that we see in the paragraph immediately afterwards at SW 17.2 is provided for in respect of these decisions. So and so it's giving rise to an internal process because of the nature of the will be refused. So that if you say, oh well, you haven't had due regard to this particular piece of evidence that I've submitted, so you can send it off for an internal review. Whereas in SW 1.6, there's no reference to an internal administrative review. Hence, I suggest that's what the drafter had in mind when they put the may into SW 1.6. And in any event,
Forgive me if this is just repetition, but why didn't it say will be rejected?
I'm afraid I don't know the answer to that.
But that's the whole.
Obviously, we need to read the amendment that was made in July of 2023, inserted the mandatory requirements of 1.5. And it seems to me that that had even if the court would have preferred the drafting, or would have been more coherent for it to have been more assertive, perhaps.
To be assertive. it's if it confers a power on the Secretary of State, then the power may be exercised. That then it gives the possibility, in an appropriate case, that notwithstanding that the application is invalid, the Secretary of State may go on to consider the application on its merits. I just don't have a problem with that, because that may cover hard cases. You know, for example, if my Lord's example of them paying the wrong fee by mistake.
Well, I'm not sure, my lady, that we're at. I'm rather in agreement with you. I hope that my submissions haven't contradicted that.
Well, you seem to be moving towards an acceptance that it should say must rather than may.
Well, the facts are the facts. It says may, and I'm happy with the interpretation that my lady's applying to it, because clearly it is coherent to have a safety valve of that kind in those circumstances.
At the moment, rather the same view that when we start talking about discretion, I mean, it might be useful to just think about what we're thinking about. It's where somebody has a discretion, it means that they've got a judgment to exercise. In this case, what's being said is that a person who submits an application which is evidently invalid is entitled to a further judgment on that. I mean, I wonder whether your position, in a sense, isn't strongest when it's at its most obvious, which is that that's absurd. That one doesn't impose the obligation to exercise a judgment by filing an invalid application. No system can sensibly operate.
That must be right.
On that basis. And in a sense that once one then begins to start talking about discretions, what, as it seems to me, you either are or might be arguing for is that old courtly phrase, which the Secretary of State may reject the application in her absolute discretion without consideration. So when one starts using expressions such as discretion, it imports one thing, but actually there was an old way of putting it, which is my call.
Yes.
Which I think is what that entails. And I mean, you may be right or you may be wrong if that's your position. You know, you may decide for some reason that seems good to you to say, well, we're not going to insist upon this or that formality in this case, because the fact that you spelt the name wrong, the fact that you've got the check wrong, or whatever it was, doesn't seem right to us to bar you on that basis. But that's your call. I mean, in a sense, I mean, that may be wrong or right, but that seems to me to be the realistic alternative to the submission that's being made to us. You're not arguing for must, which is that I bind myself never to do that. But what you are arguing for is something that's not very far away from that.
My Lord has put
is
it
that-
far
is that
more
it?
eloquently than I was managing to achieve. I mean,
It's
this.
closer to a waiver of invalidity than a substitution of treating it as valid when it isn't. And I think that's why the Upper Tribunal judge was probably right to say, well, it's if your argument is right, that it's not giving a discretion to the Secretary of State to treat something as invalid, which is valid, but rather giving rise to a power to waive the validity requirement.
Or waive some part of it, yes.
Or some part of it.
Yes, that's exactly right. I would agree with that analysis. And one can see a certain logic to having the may for that purpose in the structure of the
Well, may is one of the most complicated and interesting words in the language. And so whenever it's used, it gives rise to these sorts of issues.
Forgive me, the second strand of our submissions, and I haven't really had a chance to look at them, is that in any event, the judge was correct to refuse permission on the basis that there was.
Yes, but you're not, I mean, interested though you no doubt are in Mr. Islam's predicament. You're really concerned about the interpretation of the rules, and so in a sense, very much your tailpiece submission is that if Mr. Malik is right, it doesn't get him anywhere because there's no possible basis upon which you could have exercised any meaningful discretion in his favour.
And then that triggers, because there are a number of cases where this point is being taken. Obviously, I would also say that the prohibition on granting permission in cases where there would be no fundamental change to the outcome is relevant.
Well, you could put it, it seems to me, at two levels. Firstly, there isn't even something for you to consider. I mean, on the basis that I missed the deadline. Unfortunately, that's not going to work. But even if that failed, it wouldn't have made a difference.
Yes, and actually perhaps there's two paragraphs in Bahari which are relevant to that question, which are the last two paragraphs, 38 and 39. Just I'd invite you to perhaps read those.
I've already put 2 stars beside them.
See if there's anything else. Yes, I think that's everything I had. Thank you very much.
Thank you, Lord Mayor. Yes, Mr. Mayor.
Lord, in answer to a question by Lord Justice Peter Jackson, I think Millard and Friend sort of summarised his position in this way, and I think it was with respect Millard's formulation, and Millard and Friend agreed with it. One, there is a power to reject the application as invalid if the validity requirements are not met. And second, there is no obligation to exercise discretion in an applicant's favor if the validity requirements are not met.
I think the first one, I don't comment on the second one, but I think I put to marry the power to reject application without consideration.
Yes. So if I've understood the position correctly, this is Miller and Friends case. Now, I have no difficulty with that. And I'm entirely content for Brady and Millards to endorse those two propositions. But what I say is that those two propositions do not reflect the law completely. There are two further propositions that I invite Milady and Millard to endorse in addition to those 2 points. So the third proposition would be that there is a power to accept the application if the validity requirements are not met. And fourth, there is an obligation to consider exercising discretion if the validity requirements are not met. these 4 propositions, in my respectful submission, would accurately reflect the law. If there is a power to reject the application as invalid, cannot be sensibly suggested that there is no power to accept the application. I'm not saying, my lord, and this, my lord, this is Peter Jackson, I think sort of summarized my submissions by putting to my learned friend that I was seeking to submit that there was an obligation to exercise discretion in the appellant's favor. That isn't my case.
I never suggested that. I was suggesting that your case is that there's an obligation to consider whether to consider.
Precisely, yeah. So these 4 propositions are propositions that I invite Milady and Lords to endorse.
Well, I thought the third proposition was accepted by the Secretary of State.
Yes, I think it is.
That there is a power to accept the application.
Yes.
It's the mirror image of the power to reject it. If there's a power to reject it, there must be a power to accept it. You
Well,
would say.
Yes, I mean, if
And I answered that was why the Secretary of State's argument was that that's why the word may is used.
so
For an exceptional circumstance.
I mean, if my learned friend has accepted that in the course of his submissions, he's absolutely right. And of course, that, and you will, of course, consider what my learned friend has said in his skeleton argument at paragraph 11 and 12.3 seems to be a departure from the written case that was put
Yes.
forward.
But it's your 4th proposition, Richard, which is really the heart of it, isn't it? The obligation to consider whether to consider.
Yes. So yes, and I thought this is. I'm looking at paragraph 11 and paragraph 12, Roman 3 of Millennium Skeleton. I thought the Secretary of State's case was that the wording, and I'm quoting Millennium Skeleton argument, the wording of SW 1.6 does not arguably permit the Secretary of State to treat as valid in her discussion an application which is invalid. So if Millennium has
No, I think there may be a subtle difference here. It doesn't permit the Secretary of State to treat it as a valid application. What it does is it permits the Secretary of State to go on and consider, and notwithstanding that it's invalid, which is a subtle difference.
yeah, so
May
there is
make a difference at
Yes.
the end of the day to your argument, because your argument is
yes,
once you've got that power, however you phrase it,
yes.
there's an obligation to consider whether to exercise it.
Yes. So yes, if this is the concession that Millennium makes, he's absolutely right in making that concession. That must mean that the first sentence of paragraph 4 of the Upper Tribunal's decision and the last sentence of paragraph 4 of the Upper Tribunal's decision are wrong in law.
Well, you simply say, do not, that once you accept there's a power to reject and there's a power to accept,
Yes.
then how do you determine which of those powers to exercise? You use your discretion.
That's my
And
point.
that's at the end of the day, that's all you're saying, is that that's
So-
an inherently discretionary position.
Absolutely. I mean, so far as the law is concerned, absolutely. So these are the 4 propositions. Now, the authorities on the position outside the immigration rules are of little assistance or no assistance. These are Bihari and Afzal. We are not in that territory. Now, you will recall that in my opening submissions, I took you to the authorities about the rules that use the phrase will normally be refused or should normally be refused. And Millennium accepted that imports a discretion. He
didn't quite accept that, I think. He came close to accepting it.
now,
He said he'd feel less comfortable arguing that
now
it wasn't discretion.
well, on the 3 authorities that I've taken you to, there is absolutely no doubt that those words import a discretion. And my lord is absolutely right with respect that may is more permissive. And this is one of the points that I made in my skeleton, that the analysis in those authorities would apply with greater force to the word may.
Well, you say normally refused is a presumption, may doesn't even have the presumption.
Yes. So yes, and we know that when it comes to should normally be refused, if there is a failure to appreciate and exercise discretion, then that is a public law error that applies with greater force in this context. My Lord, Lord Justice Phillips asked my learned friend as to why the Secretary of State has not used the word will in SW 1.6, and my learned friend says, I don't know. Well, the inference that I would invite Milady and my Lords to draw, based on the analysis in Mahad, is that the Secretary of State's policy or intention was not to achieve an outcome where failure to meet with the validity requirements would result in an inevitable or automatic rejection of an application. Finally, on law, towards the end of my learned friend submissions, my Lord Justice Peter Jackson made an observation. I think that was consistent with what my lady was saying, that, well, if an application is invalid, then, if I understood the observation correctly, then it would be absurd to bring into it an element of evaluation. Now, I ask you, with respect, my lady, my lords, to look at the language of 1.6 again. Now, 1.6 tells us how the Secretary of State will reach to the conclusion that an application is valid or invalid. It says if the requirements are not met, the Secretary of State may treat the application as invalid. So the Secretary of State has to make a decision on the question of validity. And that question, in my respectful submission, has an element of discretion within it. So it's not, I'm not saying that, in my submission, it isn't, with respect, entirely accurate to look at the analysis as the application is invalid, and we are asking the Secretary of State to treat an invalid application as a valid application. The Secretary of State is being asked to do is to decide in the exercise of her discretion as to whether the application is or isn't valid. And that ought to be informed by...
You're saying the proposition assumes the answer?
It does, yes. Yes. Now, so these are my submissions on law. Now, the way... Now, if Milady and Lords are persuaded that, well, this reflects the accurate position of law so far as the four propositions are concerned, then the course to adopt, in my respectful submission, would be to allow this appeal, grant permission to apply for judicial review, and remit the judicial review claim to the Upper Tribunal to be considered on the facts. So this court would decide the law and leave it to the Upper Tribunal to decide the case on the facts. Rather than
What would be the point of doing that, Mr. Malik?
yes. So well, there would be no point of doing it if the court takes the view that, well, on the facts, this case will go nowhere.
I think we've been there before, haven't we?
It's bound to be.
But it's up to us to form a view of the facts. If we think there's something that might interest the UT, then we would remit it.
Yes, but can I just show you finally in last 30 seconds?
No, we'll take as long as you need to.
I'm very, very grateful. So on the facts, can I just take you to a list of relevant factual matters that, in my respectful submission, mean that there is enough substance in this case for it to be looked at properly.
Yes.
At the Upper Tribunal. Both sides will adduce evidence.
Right. How many points are there in
No,
this
I mean,
list?
it's written in the document, so I'm not going to...
It's in the document?
It is in the document, yes.
Yes.
Can I take you to page 72 of the bundle?
Thank you.
And so these are the pleaded grounds of judicial review. And if you look at paragraph 16, you'll see that my predecessor made 4 points as to the facts. And these facts, in my respective submission, mean that there is enough substance in this case for it to be looked at properly. So those are 4 points. The first being that the certificate was assigned on 16th of June. Secondly, departure from the convention, how it affected the applicant. The application was made 3 days after the rule changed. And the applicant had not appreciated that the application would be undermined by the 17th of July rule change. So it's just that if the applicant knew that the rules are going to change, he wouldn't have waited until 20th of July to make that application. He would have made the application on the next day. Can I just respectfully add a 5th point in that list? And that would then sort of complete the list of factual matters. The 5th point is that all other requirements of the immigration rules, including all other validity requirements, suitability requirements, and eligibility requirements are met. This is obviously a case where the applicant isn't an overstayer, suitability requirements are met, there is a certificate of sponsorship. So these are 5 points that in my respective submission would create more than fanciful prospect of success. The case on the facts isn't hopeless, and if I'm right on the issue of law, then on the facts, the case in my submission should go back to the Upper Tribunal to make a decision as to whether there was unlawful conduct on the facts of this particular case. Given that there hasn't been a substantive decision on the facts, it wouldn't be, in my respective submission, appropriate for this court to sit as a sort of first instance court on facts and to decide the issue for itself. The issue of law is obviously different. The court will make a decision on it itself. I'm very grateful. So unless I can...
No, so are we. Thank you, Mr. Malik. And thank you for very interesting arguments. We'll give them due consideration and let you have a decision and reasons at the earliest opportunity. We will hand down draft judgments if we might, for your kind assistance in spotting any obvious errors, and please try to reach an agreed order. I think we've already made an order in relation to cost issues in this case, and so that's not going to likely trouble you if the application was unsuccessful. Leave open other possibilities, and we won't need to take your time in coming back for the formal hand down of judgment, which will take place electronically in the usual way. Thank you.